Ladies and gentlemen, welcome to today's webinar. Today's seminar topic is the limits of asset protection. Our presenter today is attorney Gary Forster. If you'd like a copy of today's presentation, you'll find it in the handout section of the webinar interface. Similarly, if you have a question, you can type it into the questions section of the webinar interface. And now let me turn it over to Gary. Go ahead, Gary.
Hello, thanks so much for attending. Today we'll cover a really broad topic, the limits of asset protection. I'm going to try to hit a variety of strategies that we implement for asset protection and general planning, as well as when people go too far and why asset protection sometimes doesn't function. It'll be a lot of high points, a lot of general information, or a lot of strategies that have been used over time. And if you have a question on any detail, any further explanation on how things work, etc., there's a question section inside the GoToWebinar format. Please type the question in and we'll see the question and we'll address it as we go. And I will leave 10 minutes at the end. The CPA qualification is 50 minutes. I'll speak for 50 minutes and take questions, and then we'll also leave 10 minutes at the end for additional questions. I'm going to turn off my camera so that you can see the slides entirely, and we can start to work through the presentation. Let's go first to what we're going to do today, the agenda. We're going to hit 10 broad topics. What is asset protection? Basically, what are we really doing and what are we not doing? You know, how we can create structures and transfer assets into them and how that may be restricted. The fact that we want to avoid really stuffing everything into a plan or reacting and a late stage transfer to a creditor. You know, which jurisdictions and laws we choose and how sometimes we can't choose. Which creditors have special rights, know your enemy, so that, you know, if we are dealing with the government or a government-related creditor, how the rules change. The simplicity of certain very effective asset protection strategies, how trusts work and the history of trusts in terms of integrating that history into a modern asset protection plan, the problems with bankruptcy, and then we'll wrap up. Asset protection is not really, doesn't really involve actually being sued and running away or giving your car to your cousin or some kind of odd reactionary move to avoid someone. Basically, there are a number of ways to title assets, to structure corporate activities, to create estate planning with trusts, LLCs, etc., that are totally ethical and that are done before problems arise. And basically, this idea of asset protection is there basically existing structures and laws that are available, that anyone with assets that are exposed can utilize in an ethical way and protect them in case there in the future arises litigation or a creditor problem, etc. It's not hiding assets. It's not paying taxes. It's basically thinking ahead, planning. How will I want to utilize these assets, and what structures are available such that if I do run into a problem, what I have is not available to creditors. In a sense, what asset protection does is when problems arise, there's usually a number of defendants involved. Some of the defendants have no assets. And what asset protection planning does to whatever degree is available, to be honest with you, is it makes everyone unattractive to the plaintiff's lawyer. Basically, the same way one of the defendants has nothing and really is not a target in a lawsuit, not because they're not guilty or liable under the substance of the lawsuit, but because once they get to a judgment, there's really nothing to get. That's kind of the perspective that someone planning an asset protection is looking for. There's really nothing to get even if you go through the litigation process and come to collection. There's just nothing available, even if you win your litigation. One of the interesting issues of asset protection, it's a technical issue, but it's fairly practically interesting, is a lot of people are under the impression that there's restrictions on how we can move assets. And that's not really true until someone has a judgment against you. That it became a very practical issue years ago and was resolved in this Supreme Court, U.S. Supreme Court case called Grupo Mexicano. And what had happened was this Alliance Bond Fund became subject to intense litigation. There was a huge amount of money at stake, and defendants in the case started moving money. Now, is that a good idea? That's a different question, whether that's a good idea. Start moving money around or avoiding existing or potential creditors. But the question was, can they really do it? Can you just start moving money around? Are you allowed to do that? And there's really nothing in the law that until someone has a judgment against you prevents you from moving assets. They're your assets until a judge has said that you owe money and the assets you are thinking about moving are exposed to that judgment. It's an interesting perspective because it gives us a time frame on how and when and how the law works. The case basically says that once you've gone through your litigation and a judgment has been filed against you, then the court can get involved and stop you from moving things. Until then, if you can see on the bottom of the slide there, until then, it's really what's called a fraudulent transfer issue, and we're going to hit some of the high points of fraudulent transfer. I would quickly put you to sleep if we started to get into the details, even at this stage in the webinar. But the fraudulent transfer is the law that covers and protects a creditor with respect to the debtor moving assets around. It allows the creditor to go get the assets no matter where they go. Most of the states have adopted this Uniform Fraudulent Transfer Act, and it allows the creditors to kind of unwind these transfers. So if someone is moving things around, they have the right to move them. But if they're moving things around and in the end, the creditor gets a judgment or the plaintiff becomes a creditor and gets a judgment, it can use the Fraudulent Transfer Act to go ahead and try to reach assets that were transferred. A lot of times there's confusion as to which creditor would be protected in fraudulent transfer. So if I'm a lender, for instance, a debtor has a loan out and is paying back the loan and for some reason can no longer pay the loan or goes into litigation. Well, a transfer at that point away from the lender would be the transfer away from an existing creditor. And that's more obvious. That's an existing creditor relationship. And those creditors really enjoy a more clear path to the assets transferred. Whereas, if a doctor makes a mistake, for instance, on a patient, the doctor may be aware of it or not aware of it, and the patient may be unaware of it. but the doctor has an idea, well, I might have made a mistake on something, and starts transferring assets. Well, the patient is not yet a creditor. The patient is a future creditor. So even a future creditor, if in fact that future creditor satisfies the elements of fraudulent transfer, can go get assets that were transferred away from that future creditor, even though not yet owing money. That even though the doctor's not yet owing money to that future creditor does have rights under the Fraudulent Transfer Acts. And this goes to that. This slide goes to that issue. In Kilker v. Stillman, that's a California. That's what we call the crazy California case, where an engineer who was involved in designing, I think it was swimming pools actually, for a number of different buildings and houses, long before there was any problems, had done some pretty exotic asset protection. And the actual Fraudulent Transfer Act has also a time limit on it, a statute of limitations within which you have to try to reach the assets transferred, and after which you have no claim. There is no claim to those assets. Well, in the Stillman issue, he had created all of the design issues for these swimming pools. Years had passed, long after the statute of limitations had passed on him doing his asset protection plan. And then years later, he was pulled into court because there was a problem with the design I think it was the structures and the pools. And he was very flagrant, and he was about having done asset protection, how nothing was in his name. It really upset the judge. And this is an odd out case. This doesn't happen too much, but upset the court so profoundly that the court kind of ignored the statute of limitations and went and tried to reach Stillman's assets, even though Stillman did not have a present creditor and really could not, under any reasonable circumstance, think he had a future creditor. Not only that, the statute of limitations had passed, but the court still was interested in Stillman's assets because he was disrespectful and kind of violated an initial settlement agreement in his case. It's just something to think about when we approach these things. We want to be very conservative, and we want to present the law as it is and without attitude or any kind of disrespect to the court. The Holbert versus Shackleton case is a very insightful case. It's a Florida case. It's an older case, but really gives an idea of which creditors are protected in a fraudulent transfer claim. Shackleton was a doctor who had engaged in some asset protection. I think it was very simple asset protection. A lot of it had to do with just titling assets in joint name with his spouse. He had done this before he knew about any claims or any lawsuits against him. And then within the statute of limitations, a client or patient did have a malpractice claim. And the court, ruled that you're not transferring assets away from a creditor if the creditor is simply part of a large group that you service. That's not enough notice for that creditor to be a protected creditor under the Florida Fraudulent Transfer Act. You actually have to have some detail on that particular patient for that. In other words, that you made a mistake on that patient, or you had some particular knowledge that you were moving an asset away from that patient because you think you might have made a mistake for that patient to be protected. I'm generalizing somewhat, but the idea is that these general groups of people who could possibly be protected from the plaintiff are not protected by the Fraudulent Transfer Act. The Fraudulent Transfer Act may be utilized by creditors in two ways. The first way is we can try to prove what someone's thinking. So he moved those assets because he intended to avoid me. I was owed, or he knew I was gonna be owed money by him, and he intended to avoid me. That's actual intent. If you can prove that, you can go get the asset. And then there's constructive intent, which means you don't have to prove what the doctor was thinking, for instance. You just have to prove certain elements, and then it's he's considered to have been thinking um, that he intended to avoid that creditor. There's your actual intent. That's what was in the defendant's mind when they moved the assets. And you've got all of these factors. Are they running away? Are they hiding things? None of them are really determinative, but the court can kind of review everything and kind of decide, well, the debtor was intending to avoid the creditor, so the creditor can go back and get that asset. And then here's the constructive, where you don't have to show what was in the debtor's mind. You just have to show, if you're a present creditor, you're that lender, for instance, that the debtor moved the assets out and didn't get back an asset that the creditor could reach, right? And that the creditor became insolvent or incurred debt beyond his ability to pay his day-to-day expenses. So a present creditor basically can show that all the assets went out, not enough came back in, and there's nothing left for me to get because of this. Basically, they became insolvent on the balance sheet. In terms of a future creditor, so that was maybe a patient who one day would become a creditor, and the doctor decided, I'm going to get everything out of my name because this person may sue me in the future. They're not yet a creditor. That's a future creditor. A future creditor has to show, okay, the assets went out, not enough came back in, and basically that the doctor or the defendant could not pay his day-to-day debts. A present creditor doesn't have to show that the defendant couldn't pay their day-to-day debts. They just can show that on the balance sheet that the defendant had more debt than assets. It's a little harder if you're a future creditor. Here's the evolution of the law. Interesting enough, even since 1571, the idea of the law really hasn't changed much. It's been updated and refined over the years, but it's still basically, if someone's moving assets away from you, you can go get those assets. Offshore is very interesting. We revised an LLC statute in Nevis. Also, the trust statute was somewhat updated. And these statutes are really catered to protecting debtors or future debtors. They're not meant to receive assets from a fraudulent transfer. It's just that if these offshore vehicles are utilized, the claim of fraudulent transfer is much more difficult from a creditor or a future creditor. A lot of times, for instance, on the slide, you can see a shortened statute of limitations. In the States, you generally have between 2 and 4 years, some states are 6 years, from the transfer to go ahead and file suit, get your judgment, figure out what the defendant is owing within the statute of limitations so that you can go get the asset. Some of these offshore jurisdictions, we worked on Nevis, the difficulty for the creditor in these jurisdictions, if the law is applied, is that by the time there's a transfer and litigation's occurred, and basically the process has wound down to a judgment, a lot of times the statute of limitation on a fraudulent transfer claim, just to get the case going in one of these jurisdictions or in another jurisdiction that applies the law, for instance, Nevis, has passed. So there's no way to reach the asset on a fraudulent transfer claim. There's also these other barriers to bringing these cases, like a bond requirement. You got to post bond, and it's more difficult to prove. It's very difficult to prove these fraudulent transfers in these foreign jurisdictions. In the States, we had written an article on this a few years ago. They are updating the Fraudulent Transfer Acts. The new one is called the Uniform Voidable Transactions Act. It does make some changes. They're more like refinements. The idea is still the same. Some of the references to fraud have been removed. Fraudulent transfer is not common law fraud. Fraudulent transfer is, moving the assets. It's not necessarily hiding the transfer. It's a means by which to get the assets out of my name, so that if someone sues me, I don't have anything. It's a means by which the creditor can go and get the asset. Fraud is really the term for misleading someone for financial gain. It's a different cause of action. It drives the litigation people crazy when these fraudulent transfer claims come up, because people don't understand that it's not common law fraud. They plead it apparently differently. I don't do litigation, and it's kind of a mess. Well, this Uniform Voidable Transactions Act has taken some steps to clean that up. One of the changes I like, here's some more refinements. Some of these, when we talk about fraudulent transfer, I had mentioned insolvency. So one of the ways to prove constructive fraudulent transfer is insolvency. This talks about the asset side. So when you get into the asset side of insolvency, you've got to have these things valued, and there's no consideration given to assets of partners. For instance, that was a problem under some of the old acts and some of the common law. And some of the debts, like for instance, if someone's trying to show insolvency, they can show debts. Well, if the debt is in dispute, well, they won't get credit for that debt, and they'll have more assets, which means they're less likely to be insolvent, and that's debtor friendly, for instance. It gets a little technical. This seminar is really more of an overview. Of course, if you have a question, please write in the question, and at the end, of course, I'll be available for detailed questions. One of the things I was mentioning I really like about the Uniform Voidable Transactions Act is it cleans up. It has not, by the way, it has not been adopted by all the states. It's been adopted by, I have not last looked. I think it's about 10 states. I have not last looked at the tally. Florida has not adopted it. One of the very positive aspects of it is that what happens in these, we deal with a lot of multi-state collection issues on the analysis and litigation side, not on the planning side. And what happens is we don't know which Fraudulent Transfer Act to apply, because it may involve 3 states. All 3 states have different law. The old law basically punted. It's adopted in almost every state, where the judge can rely on a variety of factors, like where are the assets, where's the debtor, where's the plaintiff. I don't know. Everyone's looking at each other, and basically everybody argues for like a closer connection to the jurisdiction that they want, and the judge makes some kind of random decision. It's pretty much a mess. The new act actually chooses a venue, which I really like. If it's an individual debtor, it's the venue for the interpretation is the residence of the individual, and if it's a business, it's a principal place of business. If they have a lot of offices, it's the chief executive office. That is a very good update. Like I said, Florida has not adopted that yet. Here are some other claims you'll see less frequently on asset transfer. That's if you create these structures, you have to follow formalities, or you could be subject to someone the creditor looking through the structure and just avoiding all protections whatsoever. And that's the sham and disregarded structures. here's some of the defenses to fraudulent transfer, and a lot of them have to do with someone's trying to make a constructive fraudulent transfer case and prove insolvency. So a lot of times what happens is we recommend that someone leave assets inside an exposed structure so that we remove this idea that they've become financially insolvent. And it's a pretty good defense, and we've used it several times successfully. This is basically some of the exemptions that we have. The biggie in Florida, the most famous one, is the homestead exemption, which, unlike any other exemption, allows the defendant debtor to invest in a Florida homestead. And we have Havoco there, which is a case where someone was sued for a huge amount of money and just ended up taking his assets and put it into a beachfront Florida panhandle home. And that was your case where the Florida Supreme Court decided that it doesn't matter if it's a fraudulent transfer. Everything in terms of equity in that home is protected, even from an existing creditor with a judgment. So that is the case that set the precedent for the rest of the cases, including O.J. Simpson. And this Willis case is basically a confirmation that you can pay down your mortgage, and it's completely exempted from creditors. The other exemptions are not they're not exempt from the Fraudulent Transfer Act. So taxes, liens, if you take money, actually what this slide goes through, those exceptions are things you can't do in the homestead. So taxes and liens on the homestead are not exempt. You can't steal money and put it into your homestead. And I will go through the other statutory exemptions not related to the homestead in a slide or two here. Those are subject to fraudulent transfer. So homestead's not subject to fraudulent transfer, but there's some exceptions for taxes, and you can't steal money and buy a house. And then there are other creditor exemptions, but those are subject to fraudulent transfer. Just trying to clarify that for you. Homestead is basically very broad. You can incorporate the lot next to you, mobile homes, everything basically where you live is very, very, very protected. And here we start on some of the statutory exemptions below: retirement, insurance, wages. Those are statutorily exempted, but you cannot make a fraudulent transfer to a retirement plan or buy insurance to avoid a creditor. You can with a homestead. This is the next in the series. This is avoid late stage transfers, which is basically another way of saying, you know, we can't really plan for you once you have identified a very likely creditor, or you become subject to a judgment. Now we have to look at the homestead, basically. There's nothing you can do in terms of funding an insurance plan, an annuity. None of that is going to work. Those assets are available to the creditor through fraudulent transfer. This Wells Fargo Bank case is a great example. It's a very interesting case. This woman, Sabrina Barber, got in. This was the housing crisis. I think it was around 2008, where she had got into a $64 million debt. The properties now were worth $64 or 64 cents. I don't think it really mattered. And I think she got some bad advice, actually. She had a homestead, an equity in a homestead, and she liquidated the homestead, and she had other exposed assets. And she decided to dump a huge amount of both homestead and exposed cash into a Nevis West Indies LLC. But here's what she did. That was not a good idea in general, but she also funded this Nevis entity with U.S. assets. So what happens as a practical matter in these cases is that these litigation cases take forever. There's a huge amount of money expended on both sides. The judges really are kind of once a judgment is entered, they really are not looking for if a plaintiff wins, like in this case, Wells Fargo won the case, for there was a debt, this is basically a promissory note default. They're very hard to defend. If you don't pay, you don't pay. The judges are looking for the plaintiff, now creditor, to collect on these judgments. They've been sitting in court for months, if not years, and they're not really looking for someone to say, a defendant say, now that's great, but I've been asset protection. There's nothing you can get. So the judges will find a way to reach these assets. In this case, if this woman had done planning before the mortgage crisis, she'd probably be able to keep what she had, to be perfectly honest with you. And even after the homestead was totally protected, she hadn't really done planning, so it didn't work. But the judge went, this is the next slide, okay. The judge went a little overboard, I thought, but basically turned the Nevis LLC into a Florida LLC owned by a single member and just eliminated all her protections. So just keep in mind, really anything is possible if you're going to do a fraudulent transfer. If you're going to start moving assets in the face of a judgment, the judge is going to do everything possible. If you plan and structure everything before the problems, it's very rare that we see these structures breached. I have not, I guess I could say on the tape here, I have not had one breached in 27 years because I don't really get involved in advice and trying to move things when the law really doesn't call for it. We can do an analysis, we can figure out what your options are, but there's no planning after an event of liability has occurred. This gets into some technical issues. This don't be greedy, valuation concerns. It's in a nutshell, what happens on these fraudulent transfer claims is that if someone can't prove that the defendant, in the defendant's mind, intended to avoid the creditor, or like if there's a number of creditors and some may try to prove it and some may not try to prove it, that of course happens as well. What we do is we want to avoid insolvency. I had mentioned it briefly in a prior slide. And so if we can stay solvent, we can avoid constructive fraudulent transfer. If we're paying our bills and we're solvent, it's going to be hard for anyone to reach anything, even if we violated the Fraudulent Transfer Act. That's not that many people follow that, but there's a whole body of law on this stuff where we first see, okay, what went out and what came back in. If you're involved in litigation and money goes out, you buy something. Well, if what comes back in is available to the creditor, that's not a fraudulent transfer. If you send money out or assets out of value that are available to the creditor, and something comes back in that's not available to the creditor, well, that's a different issue. Most courts will not put any value on that asset. And what happens? Well, in a balance sheet test, now you start to become less solvent because you have less assets, your debts have not changed. So what we want to do, if we're concerned about the issue, when we do the planning, we value everything. We figure out what went out and what went in. Did we receive reasonably equivalent value back? In a nutshell, that's kind of how it works. If we think potentially down the road, this person has got a huge line of credit, there's no issues now, there's no reason for issue, but we're not sure that something could come up in the future. It's possible. Let's try to do transfers that really can't be viewed as fraudulent transfers so that we're not going to run into any problems. I kind of like this slide, but I mean this cartoon, but the understanding the value concept really will fortify an asset protection structure. And sometimes it involves more time in the plan, because we have to wait for appraisals, etc. Not all the clients are really excited to be waiting and paying for extra appraisals, but it can really fortify the plan. This is the choose your terrain wisely. It's a very, very interesting topic. Um, I had mentioned the Wells Fargo case, right? So what we want to do in that case involved a fraudulent transfer, and basically the law that Sabrina Barber had chosen was disregarded. What we want to do is not have any issues going on. Look at what assets are available for structuring in an asset protection plan, and then choose which jurisdiction offers the best protections, right? We have on the slide some references to what happens in litigation, right? But if we're planning, what we're doing is we're planning for the litigation, right? So the idea is, which state or national law applies best? If we're looking at a trust, which trust law applies best? If we're looking at an LLC, which LLC law applies best? And how, if we get into litigation moving forward, how do we do our best to make sure in the litigation that that law applies? Because if it does, and we've done a good plan, we're not going to lose a thing, right? One interesting piece is at the end of the slide here, you've got the application of the internal affairs doctrine, right? The internal affairs doctrine is, I think it's adopted in every state, if not every state, almost every state. Every time I look at it in a different state or country, I should say civil law country, that like common law country that have the English basis. Some of the civil law countries have the Napoleonic Code. They have totally different style law. But so it's the 50 states, and then we have some countries that are based on British law. They say, we're going to respect the internal affairs of a foreign entity, right? The question is, what does internal affairs mean? Over time, we know that if we have someone form an LLC in Delaware, and Delaware says, okay, the members need not meet every year, right? And we're in a jurisdiction that says, well, in our state, the members are required to meet every year if we form an LLC in our state, but we use Delaware. Well, the internal affairs doctrine is pretty uniformly accepted that we're going to follow Delaware law. We're going to meet our internal affairs of operation from a legal perspective are going to follow Delaware because we've adopted the internal affairs doctrine. The question is, do a lot of these asset protections inside of these entities, for instance, Delaware, if we stay on Delaware, says, if you sue a single member, solo owner of an LLC, can you reach the solo owner's equity? Delaware says absolutely not. But we're in Florida. So if I have a single member and they don't want any other members, they've come in for planning. We've recommended that they add their trust, at least trust for their kids. They say, no, I want to be a single member. And we use Delaware because Delaware has said we protect the single member. If there's a suit, a collection suit in Florida, will they follow Delaware law as an internal affairs issue? We don't know. We don't yet know that. We don't yet know that. In this case, Arroyo's was very favorable. It's in some ways somewhat uncommon to get such a lopsided decision either for the debtor or for the creditor. This was very favorable for the debtor. This was a case involving a number of states. It was a complicated case with which the plaintiff did win. And they got to the collection side of the case, and a Alabama court had the collection issue in front of it. And the Alabama the Alabama court was looking at collecting on LLC interests. So what happens is you go through this long case, the plaintiff gets a judgment, becomes a creditor, and now it's time to look for how do we get paid? And they were trying to get paid through an LLC interest in Alabama. So now we have this conflict of laws, right? Do we apply Alabama law, which says, well, maybe we can go ahead and get that LLC interest? Or do we apply Delaware law, which says, not available, not available. You cannot take the interest. And the court read its LLC statute as basically prohibiting the court from acting, or what we call attaching, going to grab the LLC interest organized in another state. It's a very, very debtor-friendly decision. If you're in Alabama, you don't face the issues that I face when we try to plan, and I don't think you face it. We don't know what the next court's going to say. I don't think you face it, where we try to plan, where we say, you're a single member. Florida's not going to protect you. We're going to go ahead and use a Delaware LLC because the law, the statute protects you. But we don't know what's going to happen when a Florida court gets a hold of it. We found out what's going to happen in Arroyo's when an Alabama court gets a hold of it. They say, no, we're going to kick it back to the jurisdiction where the LLC was organized. If you compare, we mentioned Wells Fargo v. Barber, where the court basically turned a protected Nevis LLC into a Florida LLC to reach assets of the Florida LLC, which were actually in Florida. Of course, she had done a fraudulent transfer. It was a very controversial case. There was all kinds of motivations to reach that Nevis LLC and legal ways to do it. By the way, I think there was a very a non-dramatic way, instead of changing the Nevis LLC to a Florida LLC. The fraudulent transfer acts are segregated most of the time from the LLC acts. So if she was in Florida and she bought Florida assets, she probably could just have applied the Florida LLC fraudulent transfer act, the Florida Transfer Act, to go reach the LLC and its assets, which were in Florida. I don't recall them going through that analysis, though, because they basically just turned the single member Nevis entity into a Florida entity and took it. So you can compare those two cases, one where it really wasn't as dramatic in Arroyo's, where they respected the LLC, and one where basically Ms. Barber was running from creditors, where they just said this is a joke and just ignored it completely. I think we have about, my impression is we have about 5 minutes left before questions. One of the last topics here is you have to know your enemy. You have to be very careful with this stuff when you do your planning. And of course, in litigation, it's wildly determinative of who is suing you. We have these super creditors. It's basically governmental entities. So I mentioned, we have Uniform Fraudulent Transfer Act, Uniform Fraudulent Conveyance Act. We have now the Voidable Transactions Act, which is a new version, which has not been adopted everywhere. Well, those kind of go out the window usually when we're dealing with a governmental creditor. I mean, if you owe the government money, not only do the rules change to completely favor the government, but the penalties change. The Fraudulent Transfer Act of the states is not a criminal statute. It does not put you in jail. Not only that, a lot of people don't understand there's no penalty. Basically, the creditor can go grab the asset, but there's no penalty. There's no more damages in terms of money that are generally going to be owed by the debtor. That's not true. That's not true if you don't pay the government. the IRS, there's a number of collection rules which allow for IRS fraud for incarceration. Obviously, they can take assets. That US v. Grant's an interesting case because it involves a widow who was a beneficiary of a trust that was funded through fraudulent transfer by the deceased, who didn't pay his taxes. And she got to keep most of that money. It was an offshore trust. She actually got to keep most of that money through technicalities. But be very, very careful with transferring money while you have an IRS debt. The FTC case, that's what was known as the Anderson case. The FTC basically was in litigation with these Andersons. They ended up going to jail for contempt because they decided not to pay their judgment. One other factor, apart from the law being very onerous against the debtor, is that the government really doesn't run out of money. So they kept litigating and litigating. These people were put in jail. They moved their assets through fraudulent transfer into a foreign trust and actually retain their assets. They did not have to generally pay out their assets and end up settling for pennies on the dollar with the FTC. There's some technical cases. This FTC versus Leshin, it exposes some state exemptions like life insurance and transfers into statutory exempt assets. The Olmstead case on the slide is the case where the FTC kept litigating until they got the Florida Supreme Court to pretty much eviscerate the single member LLC. Interestingly, the case also eviscerates pretty much the multi-member LLC, so the legislature had to go back in and actually save the multi-member LLC, and we ended up with a new statute, but they did not save the single-member LLC. Bilzerian was a kind of a funny case where they ended up threatening Bilzerian with jail time, and it resulted in settlement. And then you have to be careful with bankruptcy. The bankruptcy is a terrible decision if in fact you have assets to protect, because any transfers away are going to be reached. And we talked about fraudulent transfer. Basically, there's a 10-year statute which takes forever to run. Any transfers are going to be looked back upon and reached. You're going to entwine people that you transferred assets to for 10 years in this bankruptcy. There's potential jail time. This second case there, Lawrence spent 6 years in jail. He did recover quite a bit of assets, I understand. He spent 6 years in jail. I think that's the longest anyone's ever gone to jail. But you got to be very, very careful with these super creditors. I'll wrap up with this. Planning need not be complicated. Often there's titling, spousal titling, that can go a long way toward asset protection if you're worried about exposure to one spouse, such as a doctor, lawyer, architect. Sometimes the exotic is not necessary. If we're really planning in a bland way and there's nothing going on, we will rarely use a foreign trust or even a domestic asset protection trust, unless a person just wants to put a very wealthy person wants to put a piece away just in a kind of a bulletproof type vault. We can move assets offshore in a foreign entity. There's some cautionary tales here that almost all involve fraudulent transfer. Again, this is just a wrap up of use of titling, exempt assets, and protective entities. Use traditional trusts if you want to put assets away for your kids, third parties. All of that's very, very protective. And here's a reference to some of the offshore stuff and how they're sometimes breached. I mentioned bankruptcy, all those crazy cases where they put people in jail. Almost all of them involve bankruptcy or a government entity. Jail time, look back, loss of attorney-client privilege, all this stuff goes on in bankruptcy. And that's the wrap up. I think we stuck to the time frame pretty tightly. I think it's like 51 minutes. I can't tell. I'm sure there's something on here that tells me. It's about, if anyone has any questions, type them in. I have not been presented with any questions, so please take a look at the bottom of the slide if you want our contact information. If you want to do something privately, please call me or email me. And
We have a
I'm
couple
always
questions, Gary. Would you like to take
okay,
those
great.
now?
Yeah, sure.
Okay, so first question here is, if a defendant is handed a judgment, can they still move the asset's physical location without criminal and civil penalties?
Yeah, you can move a location of an asset. Um, you can not only move a location of an asset, you can change accounts, you can do whatever you want um, until you just have to be aware of the fact that someone can stop you in the litigation. It's not the movement. It's not the movement of the asset. It's the either change of the asset from an exposed asset to an exempt asset, okay, or moving the asset from being in your name to in the name of a protective structure or a person not involved in litigation. So before judgment, all of these things are available. They're still subject to fraudulent transfer. But when you get a judgment, you have to be a little careful because part of that judgment may prohibit you from moving things. If the judgment and the court does not prohibit you from moving things, you can still move things. I mean, it's not like you don't have legal title anymore. You just have to be careful. You won't likely be put in jail or anything like that. Now, if you move to a protected structure or protected entity, the court will tell you, if you're subject to the judgment, to move it back to whoever has the judgment. They will reverse that through fraudulent transfer action. And then if you don't do it, you could be in contempt of court and actually go to jail. That's a very uncommon situation, but you have to follow the court's ruling or you could be subject to civil contempt. It's not a criminal action, but it's civil contempt. And that's to kind of force you. It's a threat to force you to move back or we're going to put you in jail, and they can't leave you in jail forever. Any more
Okay,
questions?
yeah, I have two more here, and let's see if anyone else types anything in. Would it be considered a fraudulent transfer if exposed assets were transferred to an insurance policy or a spouse, or are homesteads and consuming assets by daily needs the only available options?
The answer is yes. It would be a fraudulent transfer. If you any transfer away from the defendant, from the debtor, to something that the judgment holder or to someone the judgment holder cannot reach is a fraudulent transfer, except with the homestead. The homestead is a bizarre exclusion to that, where you can actually fund a house that you're going to live in, and even a judgment holder cannot reach it. The was the end of that question something to do with contempt, or there was something? It was
No, so basically it was, can it be transferred to an insurance policy or spouse? And I think you've
right.
already answered that. You said
No,
that
and
would be
then
fraudulent transfer. And then,
right.
or are homesteads and consuming assets by
Oh,
daily needs the only
consuming. I
options?
couldn't read my own. I couldn't read my own writing. Yeah, consuming. Yeah, so the homestead is available, and yes, consuming what you have. We have found that that's not considered a fraudulent transfer because you're not altering your day-to-day activities to consume what you have. And if you use it up in terms of your day-to-day consumption, it's just gone. It's just not an asset available to creditors. Thanks for that question. Great question. Anything else, Tony?
Yes, I have a couple more here. Okay, just so I understand, who and what is protected in Florida? A single member LLC lacks protection against the member's creditors, but is a single member of the LLC at risk of the LLC's creditors, not including things like negligence, et cetera, under Florida law?
Well, there's two parts. So the inside asset. So the reason that corporations are different from LLCs is because The LLC equity is different from the corporate equity. Both entities are the same in terms of what happens inside the entity, where you do business, where you sell your widget, where you provide your services, is not going to create liability for the owner. So if you sell a defective product inside a properly formed structure, either corporate or LLC, you're not liable. That's inside asset protection. The outside is, if someone sues you, can you take your corporation? Yes, they can take your corporation. If someone sues you, can they take your LLC? Not if you have more than one member. They can lien it, but they can't take it, can't take LLC assets. The exception is if you're a single member LLC and you formed it in Florida and distributions are not likely, that's kind of an open, that has not been litigated through. Distributions are not likely, it's more or less what the statute says. Then they can take your equity. So they can't take it if you're multi-member, but single member they can take. Does that more or less answer that question?
Yeah, I think you answered it, Gary. I mean, if not, the question asker can ask
Okay.
another. Let me go to the next question here. I understand a Florida homestead is protected from creditors, but what stops creditors from going after the proceeds from the sale of the homestead? Are you then stuck in that property and unable to move to a new property?
No, great question. It's so protective, the homestead protection, even if you transferred assets in that are exposed to a lawsuit, that you can sell the home, segregate the proceeds, and buy a new home. You can even add further proceeds, get a loan, whatever you want to do. You can put the money into a new home, and that home that you live in, the new homestead, is not available to creditors. Thank you. Thanks, everyone.